So I will continue. So Business Y runs a shop called Star Tea House, selling milk tea and cakes, falling under Class 43 as a service. In contrast, Company X Star Coffee is registered in Class 30 for coffee products. However, because Star Coffees may be considered as a well-known trademark, and so under Article 191, point D of the IP law, it said that any use of an identical, similar, or even unrelated sign that causes confusion or misleads consumers regarding the well-known trademark owner is considered as an infringement. So this means that even though Y is offering service in Class 43, its use of a logo that closely resembles to the Star Coffee can still constitute the infringement. And additionally, we have here the Article 124, Clause 5, that talking about the use of a trademark includes actions like selling, offering, displaying the sign of goods and services. So Business Y, by naming their shop Star Tea House, using a logo with almost identical, displaying the sign in business operation and providing services to customer under that sign, it can easily lead consumers to believe that Star Tea House is a branch or even sub-brand of the Star Coffee. So this not only poses risk confusion, but also allows Y to unfairly benefit from the reputation of X well-known trademark, and therefore Y conduct satisfy the condition for trademark infringement. And for the last factors, which is the territorial scope, so the acts occurs in Vietnam, so the Vietnamese IP laws apply directly to this dispute. And in conclusion, Y's argument that selling milk tea instead of coffee would avoid infringement is not a valid defense under the Vietnamese law. And now comparing the Thai law and Vietnamese law regarding these questions. So under the Thailand law, using a registered trademark without permission is already considered infringement under Section 44 and 46, Clause 1 of the Trademark Act. But Thailand law goes even further because Section 46, Clause 2 introduced the passing off, which also protect the unregistered marks. If the public is likely to be misled about the origin of goods or services, the owner can prevent others from using identical or confusingly similar signs, even in different products categories. In other words, as long as there's a real risk of confusion, so Thailand law will intervene. And meanwhile, in Vietnam, it doesn't use the terms passing off, but the protection works in a similar way through Article 6, Clause 3 and Article 109, Clause 1.d. And if a trademark is neither registered nor well known, so the enforcement in Vietnam is kind of more difficult. So, in summary, both Thailand and Vietnam show the same outcome because they both recognize the infringement through the unauthorized use of a registered mark and provide protection for a well known mark. In our case, business-wise use of Star Tea House was likely to be considered infringement in both countries because the similarity is enough to confuse the consumers. And now I will invite Hoàng Anh to discuss about the task 2B.
So the task to be includes the requirements is that the evaluate the distinctiveness of the mark, and the second, does combining a common word style with a specific design color creates a protected mark or not. So we will analyze this into one by one. First, we discuss and evaluate the distinctiveness of the Star Tea House under the Section 74 of the IB law based on the following criteria. First, the Star Coffee is a well-known trademark because of the Article 4.20 and the 75. The Star Coffee is qualified as a well-known trademark because it has been widely recognized across Vietnam for over 10 years. And the second, the visual similarity creates confusion because it used Star Tea House with a logo that features nearly identical fonts and color to Star Coffee, making consumers are unable to distinguish between two marks, which violates the condition of easily noticeable specified in Article 74, Clause 1. So the third criteria is that the difference in goods service does not seem firm infringement and not create distinctiveness because although it sells another products multi in case in class 73 of the NICE classification, rather than in class 30, the law still protects well-known marks across these similar goods. And also Article 100 29 clause 1 point B, if X successfully proves that Star Coffee is a well-known trademark, its use constitutes infringement even when the goods and services differ. So in conclusion, the Star Tea House is not distinctive due to violating the Articles 74 Clause 1 and 74 Clause 2 point E, and therefore cannot be protected under Vietnamese ID law because it fails to satisfy the distinctiveness requirement in Article 72 Law 2. So next to move the second requirement, we will consider whether combining a common word style with a specific design color creates a protected mark or not. So therefore, protection depends on actually specific facts of the each mark. But in particular, in this case here, if the Star Coffee is proven to be well-known and trademark, I mean, if it successfully demonstrate that Star Coffee is a well-known trademark, in accordance with Article 91 Clause 5.c of the Rule 65 and Article 75 of IB law, even though different between classes, the mark Star Tea House cannot be protected. And the second case here, if the Star Coffee is not proven to be well-known trademark, if the company X fails to prove Star Coffee as a well-known trademark, it is just a common trademark, the mark Star Tea House can be seen as a protected mark because already is selling other products differ from the X products. Yeah, instead of selling coffee products, in spite of using a logo with nearly identical fonts and colors to Star Coffee, so the mark Star Tea House can be protected. So to sum up, whether here a common word Star combined with a specific design color elements can form a protected table trademark depend on circumstances. I think, yeah. And in this case, however, it cannot use style together with Skin Tea House due to the existence of the well-known trademark Star Coffee. So on top of that, we also have the comparison in the Thailand law in order to how to resolve this case based on the Thailand Trademark Act. So first of all, the distinctiveness requirement in Thailand, the components here, the Star Tea House includes the common English word star and also the descriptive term tea house. It also violates the section 7 paragraph 2.2, and in addition, the visual appearance of the tea house here cause confusion to the customer. Therefore, the tea house cannot have this distinctiveness in this case. And here the outcome is the same with Vietnam. However, proving distinctiveness in Vietnam is more complex and stricter than in Thailand. And the second, the use of the common word star combined with design color in the Thailand law. In this case, the use of common star together with tea house cannot be protected because there are two reasons. First of all, it lacks distinctiveness under the Section 6, Paragraph 1 and Section 7, Paragraph 2.2. And the second reason is that its use would confuse the consumers due to the visual similarity, as I mentioned before. So it constitutes the infringement by passing up under Section 76, Paragraph 2, as Kanman mentioned in previous. So therefore, combining a common word with a specific design here cannot create a protected mark in this situation, regardless of the difference in license or whether the mark Star Coffee is a common trademark or a well-known trademark. So it means that the outcome under Thailand law differs from the Vietnamese approach. Also, Vietnam may still allow protection of the mark containing a common word style and with specific design if it concerns different classes or different goods and services, and if the mark Star Coffee is not well known, it's just a common mark. So Vietnam is still allowed protection. By contrast, with Thailand is stricter. The mark cannot be protected under any trademark category when it lacks distinctive and creates the consumer confusions, as this constitutes an act of passing up. So next, we will invite to Ying introduce the next topic.
So move to the final question is that if Y is found guilty, what specific actions must they take? And we will identify under the Vietnamese law first. So if Y violate company X trademark and as the intellectual property owner, company X has the right to apply measures under the Article 198.1b of the IB law. Next slide. To protect its rights, so as the request of company X, business Y must stop the use of the Star Tea House trademark and the confusing logo, remove and destroy signboards or marketing materials or image on digital platforms, and issue a public apology acknowledging infringement and a public correction to prevent confusions among consumers. And if there are any loss like lost profit or additional cost which can be determined according to Article 204 and Article 205 of IB law, Y may need to compensate for X. Moreover, if business Y does not follow the request of company X by taking these actions according to Article 198.1c of IB law, company X has the right to request the competent state agencies to handle the act of infringement. And according to Article 202 of IB law, is the civil remedies. If the company X requests the court to apply this remedy to business Y. And besides, if business Y infringe on company X trademark that cause damages to company X, business Y will be subject to administrative penalties under Article 211.1a of IB law, and more specific penalties will be regulated under Article 3 of Decree 99, which is amended by Decree 126. So business Y may be subject to administrative penalties, including the administrative fines up to 500 million VND, forced removal of infringement elements, seizure of infringing goods, or the destruction of infringing label, size, or packaging. And in conclusions, here are the actions that one must take if they are found guilty of trademark infringement, which includes stop using Star Tea House and similar sites in an infringing manner, destroy or remove any infringing materials, and to clarify the consumer confusions, Y must provide a public apology or correction, and it may pay the damages or enforcement expenses to company X, and Y is also entitled to pay administrative fines and additional measures if it is a serious violations. So Y is subject to both administrative penalties as well as the civil remedies. And under Thai legislations, according to Section 44, in conjunction with Section 46, Paragraph 1 of the Trademark Act, the trademark owner has the right to file a lawsuit to prevent the infringement and claim compensation for damages. So in this case, when business Y is found guilty of infringing trademark Star Coffee registered by company X, as the trademark owner, company X will have the right to file a lawsuit to prevent the infringement and claim the compensations. And under Section 109 of Thai Trademark Act, It states that anyone who imitates a registered trademark in a way that misleads consumers may be punished with up to 2 years of imprisonment or a fine up to 200,000 baht or both. So Business Y use the shop name Star House together with a logo that closely resembles Star Coffee. This creates consumer confusions and qualifies as trademark imitation under this section. So, Business Y is subject to the penalties under this provision. Moreover, under Section 116, it allows Company X to request the court to issue an order stopping Y's infringing acts if there's a clear evidence of imitation, which is regulated under the Section 109. And under Section 115, all infringing goods must be confiscated, regardless of whether the court issues a convictions or not. So, any materials or products displaying the Star Tea House logo will be seized. And in conclusions, these are the actions that Business Y must take when they infringe the trademark, which include stop using the names Star Tea House and similar logo for its production, pay compensation for Company X, pay a fine not exceeding 200,000 baht, imprisonment not exceeding 2 years, and on goods that bearing the infringement trademark shall be confiscated. And here is the comparison between Vietnamese law and Thai law. So both Vietnamese and Thai law allow the trademark owner who is Company X will have the right to request Business Y to take actions, and it also allow the court to order destruction, compensation claims, and cessation of the infringing activity. However, Vietnam requires a public apology, while Thailand has stricter penalty, which is the criminal liability. So that's all our presentation. Thank you for your listening.
Dạ thầy ơi, thầy accept cho bạn Phương Anh vào với ạ.
Alo, các bạn nhóm 4 có ở đây không?
Nhóm 4 hả chị?
Nhóm 4 thuyết trình trước đi nha. Tại chị cũng không liên lạc được với thầy á. Có gì nhóm 3 thuyết trình sau.
Dạ vâng, dạ.
Right, thank you, thank you. So, welcome everyone to our group's presentations, and we are Group 4, and today we will be presenting about 2 tasks that given by our Professor Thái Cường. So, yeah, next please. Not to be time consuming, I will shift to the very first question. Next, please. Right, so we have the very first questions about the 3 conditions for informations that to be protected as a trade secrets under Vietnamese IP law. And professor also specified that it shall consider as a business secret. So under Vietnamese IP law, this concept is defined in Article 4, Clause 23 of the law on IP. You can find the latest version on yourself. And the informations that could be protected could be from the business perspective. It could be a technical or scientific information. It could be commercial information such as customer data or even financial information, and many other that the enterprise or the entrepreneurs wish to keep it as a secret. So moving forward, all the informations, we will shift right to the 3 main conditions. So here we are. Conditions number 1, to be protected as a trade secrets, the informations will neither be common or easily obtainable. What does it mean? You can find this concept under Article 100. Article 84. So this refers to the confidential nature of this industrial property. It means that, okay, trade secrets mean secrets, right? And it's meant to kept as a secret. So because it should be a secret, then it cannot be easily learned by public or easily predicted. The secrecy doesn't require all the part of that piece of information must be confidential. But as long as when you piece them together, it's become a combinations of secrecy, then yeah, it shall be fine. It still can be protected as a trade secret. So under the first condition, it leads to to the cases that couldn't be protected, or I would say unprotectable cases, which is the first thing is common knowledge, because since everyone knows, you cannot gatekeep it as a secret. Secondly, is the information that violating social ethics, social order, or national security. And this is the general requirements from Article 8, Clause 1, throughout all the concepts in Vietnamese IP law. And number 3, for vague informations, for those informations that are without clarity, couldn't be protected as a trade secret. And you can also refer to another case that falling under this ground of unprotected state, which is the piece of information that does not contain a sufficient extent of creativity for an average worker in that field, which means that it's quite similar to the concept of common knowledge. Because if an average worker of that field could easily grasp the understanding of that piece of information that you tend to keep as a trade secret, then what is the point of protecting them anyway? So that would be the very first conditions. Now coming to the second conditions, what does it